Welcome back to a series of meetings that will deal with common law history, a play that will be organized in 4 acts. And we'll start with Act 1, from form of action to precedent. The slides give you a synopsis of civil law and common law, how much they differ. We have seen in the previous part of the course that the civil law is based on books and on codes and is mostly legislative. We will discover that the common law has developed on a case-by-case basis, which does not mean that legislation doesn't have its room, and actually it occupies more and more room these days. Civil law is right-driven. You identified rights in the codes, whereas common law, as we will see, is remedy-driven. It moves from problem to solution. And of course, you may conclude from the solution that parties have rights. But remedies precede rights, as one says, in a common law setting. The last point that differentiates the system is that the civil laws we have seen tends to be general and favors abstract legislative rules as a paradigm, as a model of the rule, whereas the common law favors fact-based court rulings, which makes the law a lot more precise. And we will see that you find that degree of precision also when you are dealing with statute. All this regarding common law history has a start that I'm going to place, it may be a little bit artificial, at the time of the Norman conquest in 1066. That does not mean that there was no legal system in place before. Before the conquest, justice in England, like in most places in Europe, was chiefly local. And it was administered by 100 courts, county courts, that applied local customs. You did not have anything like a common law of the realm. After the conquest, the new dynasty, with William called the Conqueror, will set up a new feudal system that is replacing gradually the old feudal system that had existed on the island. We will see that the new dynasty will create a system of central courts that will gain power and traction as history goes. And these central courts or royal courts have gradually elaborated a common law system, a system that is called common, because it is common to the whole kingdom. Here you have visuals of the feudal system, which is a sort of pyramidal system with the king at the top. And you see that below the king, you have nobility and clergy. The clergy, back then, Roman Catholic, had much importance in the administration of the kingdom. The king was administering the kingdom with the help of the nobility and the church. Below, you see a lesser nobility with the barons and knights. And below, at the bottom of the food chain, you'll find the serfs, freemen and serfs, people who were actually cultivating the land. Why is this important? Well, it has been key in the development of a number of legal doctrines, and particularly property law. You will see that even in the United States, we have, though we never had a feudal system in place in North America, remnants of this feudal system, because relationship between different categories of owners or people who control the land are controlled by sort of personal relationships that have developed from that feudal system. An important step that was made by the new King of England, William I, was to do a big survey of his kingdom. He wanted to know what rights lords and people could have on every piece of land in the country. And it is a very, very detailed survey, because not only you have the description of every piece of land telling you where it's coming from and who controls it, but there is even a sort of census of cattle that you find in this book that is called Doomsday Book. It's been ever so important to decide property disputes in the future, but also, of course, for taxation purposes. The new dynasty otherwise did not much interfere with the sort of local management of the land. They sent sheer ives that became sheriffs that were mandatories or agents of the king to find out what was happening in the various counties. But the new monarchy has developed a system of royal courts that had their seat in the city of Westminster. You call them royal courts or courts of Westminster. The first one was the Court of King's Bench. It was named King's Bench because the king himself could sit as a judge on this court. And it was a sort of central criminal court hearing the most important criminal cases. They were called felony. Felony was the most serious crime in a feudal society. Vassals were promising allegiance to the king, and betraying this oath of allegiance was called felony. So whenever lords or lesser nobility people were acting against the royal peace, they could be tried by the Court of King's Bench. They also created a court of common pleas that had jurisdiction over civil cases, chiefly regarding land, tenures on land. This is not surprising in a feudal system that goes from top to bottom. The king, at least in theory, is the owner of his kingdom, and any dispute regarding land ownership, in a sense, impacts the royal peace, and that justifies that a central court would have jurisdiction. And by the way, even to this day, when land is abandoned and nobody is inheriting the land goes back to the crown, and the Queen of England, therefore, would be, she is in theory the owner of her kingdom, but practically inherits land when there is no heir. And the third court to be mentioned is the Court of Exchequer that comes actually from the province of Normandy. And it was a sort of court of auditors. Their task was to verify once a year the state of the royal treasury, count the monies that was in the coffers. And to do this, they were putting a big tablecloth which resembled an exchequer, a chessboard, and they were piling up the monies, and the barons of the exchequer were verifying that the accounts were accurate. And this court had jurisdiction over any revenue or tax dispute that may develop once the king starts taxing the nobility and the bourgeoisie. Originally, these royal courts had a very narrow and limited jurisdiction. The royal interest or the royal peace must be at stake to justify that a royal court would take the case, because otherwise, based on the pre-Norman conquest system, jurisdiction used to belong to the local courts, the county courts, but also the manorial courts, because the lords had a right of justice over their land. However, it clearly appeared that justice in the royal courts was a lot more efficient and reliable than local justice. And I will describe in this video a move or a shift to develop or increase the jurisdiction of the royal courts so that it goes beyond cases that, strictly speaking, impact the royal interest to cases that could be described in nowadays parlance as purely private interest driven. So the jurisdiction of these royal courts will gradually expand, and for this, new forms of actions which were necessary to move a case to these royal courts, and particularly the Court of King's Bench, will be created. And as jurisdiction expands, these royal courts will have more and more opportunities to develop a common law that is going to conflict and substitute to the local customs over time. In the late 15th century, at the time when the Tudor dynasty comes in place, when the royal power is really becoming very, very strong in the kingdom, royal courts will supersede local courts. And they actually did this by just turning around the interpretation of the rule of procedure that thus far said, you are not going to bring a case to the royal court unless it is worth a minimum of 40 shillings. You don't want these royal courts to adjudicate on petty disputes. They finally turned that rule around, saying that every case above 40 shillings should, as a rule, be adjudicated by the royal courts. That caused, of course, the local courts to be very unhappy. They were losing a lot of business that way. Royal courts were typically sitting en banc, which means full bench, 4 times a year in the Palace of Westminster, or in Westminster Hall. But during the rest of the year, they were doing circuits around the country, which means that the judge would ride a horse and go to the other important places in the kingdom to administer those cases that were impacting the royal interest. And in the United States, we have inherited that concept of circuits, and we have had, certainly in the 19th century, circuit judges riding the country to administer justice. Another invention of the royal court system is the use of a jury of ordinary citizens for fact-finding. How did the juries appear and develop in the country? Actually, when the royal judge was coming to adjudicate a case, the judge was saying, bring me 12 people of the community and I will ask them about the facts. These 12 people were actually some sort of witnesses, but the quality of the testimony they would give was very often hearsay. And typically, jurors end up saying, well, this is what I've heard, but, ask my neighbor. My neighbor was a direct witness. And gradually, royal judges found it more convenient to call the actual witnesses, but the jury would remain in place. And actually, the task of the jury was to listen to the witness, get the testimony, give a verdict based on those facts. And the task of the judge coming on circuit would simply to give a judgment over that verdict. This is the way the system of jury that is so important in the United States today came to exist or to develop in medieval England. And we, from that time, are distinguishing fact-finding by a jury from the decision on the law that is made by a judge. Now, when there was a difficult legal question, it may not be wise to have it resolved by a single judge in circuit. In that case, the parties would have to move to London, to Westminster, where the important legal question would be resolved en banc by the full bench of the court. So the system was remarkably efficient because under the supervision of a sheriff, verdicts were taken and judges were very often actually rubber stamping the decision, the verdict of the jury, deciding on the points of law. and the court in Westminster could focus on the most important legal questions. And until the 18th century, the system will function with only a handful of judges. It is quite remarkable to see that in a country that will count several million inhabitants, a handful of judges, not more than 12 of them until the 18th century, will suffice to administer justice in England and develop the common law on a case-by-case basis. The risk of inconsistency was greatly diminished by that way. Now, I alluded earlier to the writs or forms of action that needed to exist in order to bring a case to the royal court and particularly to the Court of King's Bench. A writ was actually a command made in the king's name ordering a party to do a certain thing. Now, it will sound a little bit shocking, but the plaintiff had to apply for a writ. The writ was given by the Chancery, the administration of the Lord Chancellor, that will be mentioned later on in these videos. And it actually ordered the defendant to either to give satisfaction to the plaintiff, or if having arguments to defend the case, appear before a royal court. So the writ would include a short and standardized statement of the fact. It was actually a pre-written form that would be used, in a case. These writs were specialized. It was not a general writ where you would write, the facts of the case. But depending on the nature of the case, you had to apply for this or that writ. I will give examples in a few seconds. And the problem was that if you started the case with the wrong writ, you could not shift horses, in the course of the proceedings. You had to start the case all over again with the delivery of a different writ, as if for every writ corresponded a sort of civil code, a code of civil procedure, I mean to say. You have here example of all the writs. The first one that I will describe was the writ of debt. Imagine that A has been lending money to B and B is not reimbursing the money. A would have an action against B. You would have to apply for the writ of debt, asking anyone owing a liquidated sum of money to pay it back to the plaintiff. So receiving the writ of debt, the defendant or debtor had two options. Either you know that you owe the money and you better pay the money right now because you don't want to mess with the justice of the royal courts. It's going to be very expensive at the end of the day. But if you have argument, if, for example, your argument is that you have already repaid the money, then you have the right to appear in court and present your argument. Next in line, I have the writ of covenant. Covenant, the word is used in the Bible and the Arch of the Covenant, an alliance, a pact that is made between two people. Whenever A had promised to B to give a piece of land after death, to give his right on the land after death, you would do that on a formal document that you would call a deed, and you would affix your seal at the end of the document. And if you are not an important person owning a seal, you would ask your local lord to affix his seal to the document. Now, the party making a promise on a deed under seal could, in case of non-performance, be summoned to appear before the royal courts under a writ of covenant. You had also the writ of trespass. Trespass, since you study tort, is a term that is probably already familiar to you. There was trespass whenever a person was assaulting another party or doing, any kind of physical violence, called back then battery. You could have also trespass to land, which was invading the land of someone else or breaking in, or trespass to goods or chattel if you were actually taking away cattle that belonged to another person. So in all these cases, the victim had an avenue to obtain damages or restitution of cattle or whatever remedy the court would found appropriate by the use of the writ of trespass, which is the ancestor of all our modern tort action. You had travail or détenu. All these words actually come from French. Travail comes from trouver, to find. You find a third party in possession of something that belongs to you. This is not, you would go either for trespass if the person took away the thing directly from you, or you would use travail if the thing is in the hand of a third party that may have purchased actually the property from the trespasser. So restitution was based on the writ of travail. You also had détenu, and there were big conflict and litigation whenever you were deprived of your property, whether you had to use travail and détenu. And way down the road, they had to merge these two actions to simplify the law. But all this shows that the administration of the law was very formalistic. You had to identify the proper writ. At times it was subtle, like in the case of travail and détenu. The writ of right, the one at the bottom of my list, is actually an action that could be used by anyone who was dispossessed from some right over the land. And and that is also an interesting phenomenon, because normally disputes regarding land had to go to the Court of Common Pleas, but the Court of King's Bench has been stealing some of the Court of Common Pleas business by developing the writ of right. And you see, by the way, that the Court of King's Bench, that was originally a central criminal court, is by the 13th and 14th century doing much else and is adjudicating civil law disputes. But they were very, very artful, because you see, the whole theory was that if the defendants disobeyed the writ, which was an order in the king's name to pay damages, give back property, etc., you disobeyed an order that was given in the king's name. You were disturbing the royal peace, and the case became almost a criminal one, and that justified the seizure of the royal court. So you see that they are using artificial ways to expand their jurisdiction and literally over time swallow most of the jurisdiction or of cases that naturally should have gone to the lower courts. I'm going to elaborate a little bit on the example of trespass. Trespass was the formula in Latin, say, vi et armis contra pacem domino regis. You've been acting by force and using arms against the peace of the king. That's what the writ would say. But since the scope of the action was a little bit narrow, they allowed, and it took a statute to do that, trespass on the case if the wrongful act was not caused directly or by force of violence. You could get a writ in consimili casu, an action on the case, which would open up an avenue to the royal court in a case of simple negligence, when the damage is caused by negligence rather than by intent. You see how the Court of King's Bench is working and developing these writs to its advantage to take more and more cases that really should have gone to the local court. They even further down the road developed the use of trespass on the case in disputes that would look nowadays like contract disputes, but I will discuss that on one of the other videos. With this slide, I'm showing you that the system of writ or special forms of action has been transplanted to North America. You have here an example of a writ of trespass in the state of New York. So what I'm describing here has been at least at some point relevant in the United States, but I will show you, the relevant and how it informs and impacts the way we develop the law in the United States, even in the 21st century. Because from everything that I have said thus far, you see that the law has been developing from procedural thinking towards developing some substantive law. The focus of the court action was to found the proper action and present it the proper way. It's only in the 19th century that these old specialized writs will be replaced by one category of writs, the writ of summons, that could be used in any sort of case. And this has happened in England, but also in the United States. However, as the great historian of the common law Maitland was heard saying, or as he wrote in The Form of Actions as Common Law, the old forms of action we have buried, but they still rule us from their graves. What does Maitland actually mean here? We may no longer have the writ of trespass, but your book on tort law is still discussing trespass to the person, trespass to land, or trespass to goods and chattel. All the categories that we have in common law thinking developed actually from these old writs. And you will see several examples in another video. So the legal concepts have been shaped by the old forms of action. It's a little bit like baking. To bake a cake, you put the dough into a form, you put it in the oven, with the form, and then when it is out of the oven, it has taken shape. You may dispose of the form or put it back to a cabinet to use it another time, but the cake still has the shape of the form. And this is exactly what is happening with the legal categories in the common law system. And we will see later a few more examples. This procedural thinking also shows you how the system is moving. Rather than thinking in terms of rights, like we tend to do in the civil law tradition, you are constantly, whenever you have a problem or a dispute, thinking, what is the remedy to this case? Okay. How can I bring the other party in court? What sort of action do I have to use? So remedies precede rights. And of course, you can explain the common law system using the language of rights, but the thinking is more in terms of remedies. And you may say that when there is no remedy, there is no right. You have this obsession in the common law system about the judicial avenue. If there is no way of making your point in court, it's purely theoretical, to say that you may have a right. So access to justice, to the court, all this has a lot more importance in the civil law. In the civil law, it's a sort of obvious. The moment you identify a right, there should be a way, of bringing the case to a court. And as time went, as these forms, specialized forms of actions have vanished or disappeared, you see that the law will develop from precedent to precedent. As Maine in early common law and custom say, substantive law emerged from the forms of action. It has been secreted in the interstices of procedural law. Whenever you read these old cases, they're very hard to understand because 90% of the discussion is about procedure and very little about substance. So though we have abolished these old writs, they shape the modern concept as I alluded to regarding to torts. And you will see also in the law of contract, but we will revisit that example in another video. In order to use the writ of a sumsit, that was the contractual action created in the 16th century, you had to prove that there was an agreement, but that this agreement is supported by consideration. Otherwise, you do not have a contract. These were actually the requirements as they appeared in the writ of a sumsit. I will finish with a few visuals. Here you have a depiction of the yearbooks, which are the ancestors to the law reports that have been published from the 16th and 17th century onwards. Originally, future lawyers, apprentices who were following their masters in court were taking notes, and the best notes were published in yearbooks that were written actually in Old French, or Law French, as we call it. Very difficult to read for someone who does not know French. Dire qu'il est mort sans dire s'il est mort, il n'est pas en vie. For me, French, I can make sense of this. Car il a dit, primo deliberatum, before the deliberation. You have a mix of French and Latin. It's extremely difficult for legal historians who know only English. And the good news is that a good friend of mine, who is professor of legal history at Boston University, Professor David Sipe, has retranslated all these yearbooks and presented them on a website, and he's using modern language. You will see many examples of law French, or words that come from the French language. Now you will say, but Professor, why French? Well, don't forget that Normandy was part of France. And when William came from Normandy to England, he spoke French. And during the first centuries, the Norman dynasty, the Plantagenets, as they were called then, were speaking French in their court. It's only after the 100-Year War when the English lost control of the western part of France, because actually the British nobility was spending more time in France than in England, that the use of French has been on the decline and that the English language developed. But so many terms are still used. When you start a hearing in the US Supreme Court, you will hear oyez, 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 which means here, here, here. You know, the court is in session. The court sits en banc, which means it's the French for bench. The word tort comes from the French. It's the French word for tort. Tortfeasor is the faiseur de tort. You have in the law property concept like profits à prendre, when you have the right to take benefit, to hunt, for example, on someone else's land. You have estates pour autre vie, which means for another life, or another word that I like, the doctrine of estoppel is named after étoupe, which was sort of rough cotton that you were using to plug a leak, and you stop the leak to happen, hence the word estoppel. This slides are showing you the inns of court that have been so important and essential in the training of the lawyers from the Middle Ages till to this day. You cannot become a barrister in England if you are not a member of an Inn of Court. And they have been the sort of ancestors to the law schools. And another video is taking you to this world of the Inns of Court, but I wanted you to have a peek and see what they look like, beautiful medieval building. And even nowadays, barristers who plead the most important cases in the central courts based in London have their chambers in the Inns of Court. And yes, they still wear the wig. The United States tried to emit a little bit the Inns of Court. We have Inns of Court in the US. They're sort of club of the best jurists, and the best among you may be invited to join the Inn of Court in the course of your third year. This is the end of this presentation. I will meet you again in a discussion of common law and equity. Thank you for your attention.